We will start our meeting. We are here in the first half hour of our meeting today to pursuant to Standing Order 110 and 111 in order of Council appointment of Richard Fiarchuk. Hey, all right, to the position of Law Clerk. And sir, if you have an opening statement you'd like to share with us, that would be great, and then we'll ask you a few questions.
Thank you, Mr. Chair, les honorables députés. You have a copy of my statement, but I would like to present it. Je vous remercie de m'avoir invité à comparaître devant le comité pour...
I would like to thank you for inviting me to appear before you to discuss my qualifications and competencies to perform the duties of the law clerk in Parliamentary Council.
That this is a great honor and privilege to have been given the opportunity to serve this House and its members. I will do my utmost to discharge these duties in a manner that justifies the trust you have shown in me. Vous avez devant vous une copie de mon curriculum.
You have before you a copy of my curriculum vitae. I do not intend to take you through it in detail, but instead wanted to touch on the major themes as they relate to my duties as law clerk. When I first reviewed the description of the position, it was apparent to me that there were two very different roles. One role, and borrowing from a text of the Speaker of the House, is to act as in-house counsel to the House of Commons and to the members of Parliament. The other role relates to the specialized support provided in the legislative context, particularly in respect to private members' bills and their amendments. In choosing someone to take this role, it would have been open to look to a candidate well-grounded in one or the other of these domains. Finding someone with mastery of both sets would be a challenge, I think.
For council side of the ledger. In this role, many of the functions are very like those that I performed while with two federal crown corporations, the National Capital Commission and Atomic Energy of Canada Limited. This involved, amongst other things, providing legal advice and support in matters related to contractual obligations, labor and employment law, and litigation, for example, while also serving as part of senior management in terms of corporate governance and planning. What is different about the position of the law clerk is that legal advice and support must also be provided in respect of matters that are unique to the House. Matters of privilege are first and foremost here, but also matters of constitutional and parliamentary law that would not typically arise in other entities or contexts. However, when I moved from private practice to the NCC, and again from the NCC to AECL, I had very quickly to become adept in areas of the law where previously I had had no personal hands-on experience. I'm a quick study, and whether it was access to information and privacy, or the legal implications for my client of the differing approaches of nations to dealing with nuclear liability, these were areas in which I became conversant reasonably quickly. J'aimerais maintenant aborder le volet soutien à la rédaction.
I'd now like to touch on the areas of legislative drafting support. While I was both at the NCC and the AECL, I had been involved with the legislative and regulatory drafting process in matters related specifically to both of these two Crown corporations. I was also involved with the project undertaken by the Department of Justice to ensure that all federal legislation spoke equally in English and French and both judicial contexts, the common law and the civil law. I had some experiences here, but will need to strengthen my abilities in this area, and I have the confidence that I can do so. I wanted to highlight something else that was unusual about the NCC, in that it owned real property and assets on both sides of the Ottawa River, and therefore conducted programs on both sides and therefore in both legal systems. While my formal legal studies were of common law, and I'm called to the Ontario Bar, I have more than a passing exposure to civil law regime, and I think that this is a valuable asset to the in-house counsel role.
Atomic Energy Canada, I practiced in a highly regulated environment and one that was subject to considerable external scrutiny. I believe that too will bear dividends in my new role. I would now be happy to answer any questions that you may have for me in English ou bien en français. Thank you.
Thank you very much. We'll go to questions. Let's go. We've got 7-minute rounds. We'll try and do one of them. Mr. Reid?
Thank you very much. I just wanted to start by asking you if you'd agree with this general characterization of one of the aspects that makes your job unique. And I could be wrong, so I'm genuinely interested in what you have to say on this. It seems to me that there's an unusual situation that exists, that's an unusual tension that is inherent in our Constitution, in that the Constitution, the written Constitution, discusses the idea that Parliament carries on and inherits privileges associated with Parliament in the United Kingdom. We have a Constitution modeled on and similar to that of the United Kingdom, and that implies that Parliament's privileges have some kind of protection. And there's a need to draw boundaries around those and ensure that they are respected. However, ultimately, unlike in Britain, those boundaries, if push came to shove, I suppose would be resolvable through the courts, and thus someone who deals in the law as opposed to the conventions relating to parliamentary privilege would have some say in that and presumably have to develop some opinions on that. I'm just curious as to thoughts you might have on this and whether it actually is a serious area of concern and what you have to say about it.
First of all, you've touched on an important area. I will say this is my 11th day in role. I haven't yet developed the level of mastery of the nuances of constitutional and parliamentary law that I need to have in this role. But what I'm sensitive to and what I'm alive to is that, for instance, there are domains in which Parliament has enacted legislation, in effect, to carve out areas that would historically have been the subject matter of privilege. So I'm alive to this issue, and I can tell you that the briefings I'm getting from my staff are sort of like sipping water from a fire hose right now in terms of trying to develop the fluency that I will have to have with these concepts. What I can assure you, as I said in my opening comments, is that I'm alive not just to this, but an array of issues that raise profound questions, and that I and my staff will be expected to respond to. And maybe that's another thing that I need to point to. The good news for me is that I'm not alone in this position. I have a team of people and a long tradition of having worked in these very, very sensitive questions, and I intend to make full use of that. I believe I have the full support of the team, and I certainly am encouraged and pleased by the kind of welcome that I've received from them and the kind of briefings that they have already started providing for me before I arrived. So I'll ask you to give me a little time to develop the kind of mastery that I need. I understand you have considerable experience in this domain, and it is an important issue, but I think it would be a bit premature for me to try to expound on these issues right now.
Right, okay. Just out of curiosity, could you just expand on your team, who they are, and how much? Obviously, I know they're very good, very professional. We've seen them at work in the past, but you just tell us a little bit of who they are and what they do.
Well, we have the team really breaks down into two distinct functions. We have what I'll call the legal side of the team and the legislative support side of the team. You've probably, well, you have met and I'm sure dealt with Richard Denis, who's the deputy law clerk. We have as well, amongst the other lawyers that we have, Steve Chaplin, Catherine Baudouin, and Marie-Jeanne Charette, Greg Tardy, Louis Maccabé. So we have a good group of lawyers with an array of both calls to the bar and experience in different domains that form that side of the house, I'll call it. And then we have the legislative side of the house, who are providing the direct support for the private members' business, and they're headed up by Marie-André Roy. We also have Doug Ward, who's one of the drafters there. I'll be frank, I've been taking things in little bites. I started on the legal side, and I have not worked as closely yet with Marie-André and her group for a good reason. They are quite occupied right now with a lot of private members' business that's coming forward at this point in the sittings. So, but again, I have a lot of confidence in what I've seen so far in their abilities, and I can see, just in terms of their capacity to respond to demands in a timely fashion, that this is something that is very encouraging for me. So that gives you a bit of a flavor. And there's, of course, a team behind them supporting in terms of the administration of the office as well.
Thank you. Do we have any time left, Mr. Chair?
A minute and a bit.
Okay, just curious. Obviously, we are not the only parliamentary body in the country. There's 10 provincial legislatures. Does each of them have a parallel office to your own, or do they structure it differently from the way we do it here?
No, my understanding is that they do, and I have reached out to the group that is the association that represents that group, and I'll be meeting with all of my colleagues and peers in Edmonton in September. Frankly, for a couple of reasons. One, to build that network with them, and to learn what I can from them. So there are like offices in the other jurisdictions.
Thank you very much.
Reid? I have Mr. Cullen for 7 minutes, or any portion thereof.
Thank you. Any portion thereof. I'm in politics, Chair. It'll be the entire portion. Trust me. Mr. Fiorchuk, welcome. I hope I didn't butcher your name too badly. A sincere welcome from the official opposition, New Democrats. You have a very challenging job. You have an impressive resume. Members of Parliament and therefore Canadians rely a great deal on the advice that we receive from your office. That it's of the highest quality, which it has always been, that it is nonpartisan as it has always been. Parliament's a unique body. We like to think of ourselves as very unique, but unique compared to other institutions, and is highly charged environment. I'm sure you can appreciate that. As I said, you have an impressive CV. And you made some mention of this in your comments. I'm searching for, from your experience, what you're going to rely on in order to make the decisions that you'll have to make when offering us legal counsel in this unique and politically charged environment. Have you had other experiences that you'll be able to draw from in which you've had to make those kinds of decisions in that kind of context?
If you're talking about the politically charged environment, I'm not going to make equivalent the experience that I had, for example, working at the National Capital Commission to here. It's a whole different, several different quantum steps between the two. But there were nevertheless issues that polarized the local community, in which the NCC was involved during the 19 years that I was there, and certainly that. Was a real learning experience for me in terms of dealing with very, very strongly held views, frequently on opposing sides of issues, and learning how to navigate in those waters was important. But I just want to bring this nuance to it. I guess there's different types of advice that you end up giving as legal counsel, and the rule that I always held first and foremost was, if I'm acting purely in the role of legal counsel and there's a decision to be taken, the objective I want to achieve is that the decision maker is a fully informed buyer at the time that they make the decision. It's not frequently the case that the lawyer is making the decision. He's providing the legal analysis that supports the decision maker moving forward. That's not always the case depending on where you are in the management structure of the organization. As I became part of the management team at the NCC, it became one thing to have my lawyer's hat on and saying, here are the legal implications of what you're proposing to do, or what are the options that you're considering. My job is to make sure that you're fully conversant on those. But then, as a member of the management team, I have a role to play there in terms of offering my thoughts on what's the preferred way to go.
Okay. Dans cette situation, quelle qualification vous avez pour...
In this context, what qualifications would you cite in this area? We have a few issues right now, of course, qualifying a scandal in the Senate, Mr. Duffy, Mr. Wright, and it's not very clear.
An answer that you can give as counsel to say this is absolutely where the law lands and you will be correct in saying this. You present options, risks, and whatnot. But in the role that you're playing right now, incorporating constitutional aspects of this, which might be different, which are different than corporate aspects, that a similar affair of a check or something or some potential malfeasance would look different under an NCC lens, under AECL, under a corporate lens than it does here in Parliament. That you mentioned earlier about relying upon the knowledge, the corporate knowledge, I suppose to use a term, that exists within your team right now. That gives me some assurance, to be frank. Again, your resume is very impressive. But the application of those experiences to this particular environment, when the advice that you will be offering us could be potentially so important as to the sanctity of Parliament and its ability to do its work, hold government to account. Do you follow my... I'm being very... I want to be very respectful. Absolutely.
No, and I appreciate that. I guess my response is this. As I said, I'm not going to pretend that I have experience that I don't have. Mm-hmm. I've offered you the kinds of experience that I do have. That's the closest touch point to the kind of thing you're talking about. But what I can offer you is this, and I think that the CV bears this out. I'm thorough in terms of preparing and responding to things. I have a good work ethic. I have a good teamwork ethic as well with the group that's around me. What I found is that the thing that best serves me, whatever the situation, is the preparation, is to have the best possible understanding. I'm not going to pretend, as I said, that the kind of nuanced advice that I may have been giving in the previous context compares, but it gives me some touch points for this. And like I said, I'm a quick study, not just on the legal side, but on the broader dynamic. And I will rely a lot on that corporate knowledge in the group to inform my ability to respond to these kinds of challenges.
Thank you for that. This is an unusual type of job interview. It's not really, but is, by the acts of Parliament and how you come to the role that you have. This committee, and we ask questions that you may see in a normal job interview, but in a different context. One of your roles in offering advice to parliamentarians on all sides of the House is the ability to speak truth to power, where government or a member of the opposition presents your office with some legislation that is unconstitutional according to your advice. Yet it may be politically important for a government or an opposition member to present that bill. What experience have you had in having to speak that truth to power, giving advice that people don't want to hear, yet is important for, again, protecting Canadians and right to have a parliament and a government that actually respects our Constitution?
I think what you're asking is, it's the essential role of what the lawyer does for the client always. I've had many times, both in private practice and in public practice, where the client didn't want to hear what I was telling them. But it goes back to that sort of opening rule that I stated for you, which is that I view my role when I'm wearing the hat of lawyer, especially when there are competing options, to make sure that the client is fully apprised of all of the risks and consequences of what they're going to do. And I have no difficulty telling them that. And in a sense, I have the ability to stand off and say, I'm giving you legal advice. You're going to be making the decision. But when you do it, you're going to be an informed buyer. You're going to understand the implications that flow. I think that's the best I can do as the lawyer in terms of doing that. And I remember when I first came into public practice, it was very common to hear this kind of conversation where he doesn't want to hear that. And I found that totally absurd, because the consequences of someone not hearing and being ill-prepared or blindsided, in my view, were far worse than being confronted with your honest take on what the story is. That's been a guiding principle for me throughout private sector days, public sector days. And it's the way I view my role. So as I said, I take very seriously the trust that you're placing in me. I consider this an incredible honor, and I'm going to do everything I can to discharge that function just in the fashion that I've said.
Thank you.
Mr. Cullen. Mr. LeBlanc, 7 minutes, please.
Thank you, Mr. Chairman. Mr. Fiarchuk, welcome. Welcome to Parliament. I share my colleagues' views. Your resume and your experience is impressive. We're lucky that somebody of your experience was interested in assuming what I'm sure you'll find at some points is a nightmare function. I note that in 1975 you graduated from St. Michael's College at the University of Toronto. A decade later, I got my first choice of colleges. I went to Trinity. So I'm glad to see you're a U of T grad. I wanted to follow up perhaps Mr. Cullen's questions, and you're right, I had a brief experience in the private practice of law in New Brunswick. I've often wondered about people who work as legal advisors in a context as complicated and as treacherous as Parliament or the House of Commons, where you'll have people asking you, I hope in good faith, for legal advice, for a legal opinion, with perhaps completely contradictory objectives, hoping you'll say that such and such is possible, or such and such is not, or something is wise or is unwise, and you may, on the exact same issue, probably more than any other function. I was trying to imagine a large Crown corporation like AECL or an organization like the National Capital Commission, which, as you correctly noted, at various times on various issues becomes politicized, often around different development initiatives or different policies or decisions they make, obviously, in this city. And I was trying to, my experience as a parliamentarian, different, to be fair, in a minority context than a majority context, where there's a bit more predictability both in committee deliberations and in votes of the House itself. But one of the things that I was struck by, albeit in the minority context of either Mr. Martin or Mr. Harper's government before 2011, was the ability of parliamentarians or committees to get access to information, not in the context of the legislation, of the statute, but to be able to dig out, to tease out particular information from governments or, in some cases, from other parliamentarians. And the Senate process that may be undertaken in the coming weeks will again sort of touch this idea of the ability of people to get information which either people claim as parliamentary privilege or, in the solicitor-client context, as solicitor-client privilege. I'm wondering if, in your experience, either at the NCC, and you'll forgive me, I don't understand the extent to which access to information applies to the National Capital Commission or to AECL. I see in your resume that you were involved in the access to information and privacy context, so I assume it fully applies to the NCC.
Fully applied at the NCC. There was an area that was carved out of the application of ATIP in the context of AECL for obvious reasons.
Sure, business and commercial.
Well, it had to do with some of the sensitivity of the materials that AECL deals with.
Sure, and there would be the normal protections of commercial or business information. But from your experience, maybe in private practice, how do you balance out, because I think, and I'd be curious to have you come back in a couple of years and see if your impressions that you have after 2 weeks are the same as you might have after 2 years. My sense is that one of the functions of parliamentarians is to get access to information, not in the statutory context, although that is one of the instruments, but to be able to represent their constituents or speak in Parliament based on facts and information, which often, for contradictory reasons, a particular institution or a particular government may not want to be so transparent in giving. I'm wondering if you had any experience in your practice with dealing with the decision to advise somebody to disclose something or not, based either on statute or on perhaps a litigation context that you saw either coming down the line or before you presently.
There's sort of two flavors to your question. I'm going to try to deal with both of them. There were many times on one side of your question where you talked about advising to disclose, where notionally, under, let's say, ATIP, we had an available exemption for which a plausible argument could be made. But again, now wearing my management hat, the view was it better serves the organization to release this information than to resist on the basis of a plausible invocation of that exception. So yeah, I've been there. We, as I said, in the role of manager, and part of the senior management team, you're going to weigh a lot of different consequences than just the purely legal sort of binary obligation. Is it eligible to be suppressed or withheld, or is it to be disclosed? When you start talking about litigation, I must admit that I have an instinct that goes back to my private practice days, and I guess it's something that started, back in law school. I remember Arthur Maloney came to speak to us at Western, one of the most distinguished practitioners, and he said, the mere fact that you've been retained is a matter of privilege, not something to be disclosed without your client's instruction. So certainly during my private practice days, that was a habit that became quite inculcated in me. And I still have that natural instinct. Any lawyer will. And when you talk about litigation, especially when you're talking about the disclosure of information that might expose your client, that's something that, as I said, I will tend to start from that initial position because it's the one that I've lived for 30 years or so. And having said that, when there have been times when, on balancing all the factors, okay, you've made the determination as part of the management team that you're going to make a release of information. That's something that I've been prepared to recommend as well. It's something, I guess, that grows with your maturity too. When you're a younger lawyer, you might tend to be a little more just binary about stuff. Well, the law says this, that's what I'm going to do. As you become a little more experienced about the implications, you may be prepared to take a more nuanced view and say, what really is in the client's better interest? I don't know if that answers.
No, it does. Thank you very much.
Thank you. We've completed our time today. Thank you. Monsieur LeBlanc invited you back in 2 years. I'd like to invite you back more often if you feel you need to. This is a great place you can come, and we're happy to have you come and share information with us.
Thank you, all members. I'm really, I guess I have to say I'm excited about the prospect of being given the opportunity to serve this House and its members. And if you want me back, you know where I live.
Just call. All right. Thank you. We will suspend for 2 minutes while we change witnesses and move on to the second part of our meeting today. Started. Welcome, Monsieur Mellon. Happy to have you here today. Committee, we're here today pursuant to Standing Order 84-1, the main estimates, vote 15 under Privy Council, and other issues pertaining to Elections Canada. Monsieur Mellon, I know you have an opening statement for us. Would you be happy to share that with us and introduce your guests that are here with you today, too? It would be great. After your opening statement, we'll go to rounds of questioning.
Thank you, Mr. Chair. Merci, Monsieur le Président, de l'invitation à comparaître aujourd'hui devant le comité.
Thank you, Mr. Chairman, for this invitation to appear today. I'm accompanied by Mr. Stéphane Perrault, Deputy Chief Electoral Officer, Legal Services, Compliance Investigations. On my right, Mr. Roussel, Registration and Voting Services. And on my far left, Mr. Bellana de Gefe, Deputy Chief Electoral Officer, Policy Planning and Public Affairs. Last year, I committed to produce 2 reports. The first was in response to the occurrence of deceptive communications with electors during the 2011 general election. I transmitted this report to the Speaker on March 26, 2013. The second was the result of a comprehensive review undertaken in light of procedural and record-keeping errors by election officers during that same election. I shared this report directly with the committee on the 30th of April last. I am pleased to discuss both of these reports today, as well as my office's main estimates for 2013-14.
Titled Preventing Deceptive Communications with Electors. For electors, communications with parties and candidates during an election is fundamental to effective participation. Parties and candidates need also to contact individual electors to engage them in the political process. With new technology and increasingly sophisticated software, political parties and entities can more readily understand demographics and identify elector preferences, as well as communicate with them. However, these communications need to be regulated. Abusive communications that convey false information or mislead electors are likely to undermine trust not only in the perpetrators, but in the political process as a whole. The recommendations that I put forward in my report are designed to reconcile those different interests. While some of them are administrative, most require legislative change. I would like to highlight a few recommendations that require legislative intervention. The first responds to Canadians' concern regarding what may be a significant amount of personal information gathered by parties in their databases. Electors need and expect assurances that their personal information is used for proper purposes and is adequately safeguarded. There are principles accepted throughout the world with regard to protection of personal information that apply in Canada to most non-governmental organizations, large or small. They relate to collection, use, and dissemination, and to the responsibility for each organization must assume for personal information under its control. I recommend that political parties be required by law to have in place policies and rules that are in line with these privacy principles before receiving voter lists from Elections Canada. A second set of recommendations is designed to better regulate telephone calls made by political entities to electors. I recommend new rules governing calls to electors to complement current CRTC rules on unsolicited communication. For example, in all cases, callers should be required to disclose the name of the candidate or party on whose behalf they are calling. As well, political entities should be required to provide specific information about telemarketing services on a timely basis. On the other hand, companies providing the services should be required to keep records of communication made during an election period. The records should be disclosed to the Commissioner to facilitate an investigation following judicial authorization. These recommendations would ensure greater transparency of campaign activities, a more rapid intervention in the case of complaints, and more effective investigations. Indeed, The investigations into deceptive calls have made us keenly aware that the Commissioner of Canada election needs better tools to do his work. Good rules are of little use if they cannot be enforced. I have recommended that the Commissioner be granted the powers, subject to prior judicial authorization, to compel persons to provide information relevant to an investigation, either by testifying or by producing documents. The Commissioner strongly supports this recommendation. Under the Charter of Rights, information so obtained could not be used against persons required to testify. However, it could help to determine whether an offense has indeed been committed and thus make it possible to act more quickly and to facilitate investigation. Such a power already exists in most provincial electoral statutes, and at the federal level, it also exists under the Competition Act. Telles sont mes principales recommandations pour prévenir les...
Those are my key recommendations preventing deceptive communications. I'd like to turn now to the report entitled Compliance Review, dealing with Voter Day procedures. As the committee is already aware, in the last general election, there were a number of procedural and record-keeping errors on Election Day for registration and voter identification. While there is no evidence that unqualified electors were allowed to vote, the conduct of an election must be accounted for through proper record keeping. I therefore commissioned an independent electoral expert, Mr. Harry Neufeld, to conduct a rigorous and comprehensive review to understand the scope and the causes of these errors, and to engage various stakeholders in proposing solutions for the next general election and beyond. We agree with Mr. Neufeld that in the longer term, a fundamental redesign of the voting process is required. A simplified process is vital to sustain an electoral system that one day every 4 years relies on over 2,400 individual citizens to serve their neighbors and democracy in the role of election officers. The redesign of the voting process is a very large undertaking that demands a very prudent approach. As required under Section 18(1) of the Act, I intend to seek the approval of this committee, as well as the Senate committee responsible for electoral matters, to pilot a new voting model. This model would encompass new technology at the polls and a realignment of electoral officers' tasks. Assuming a successful pilot test, my office would propose significant legislative reform to implement the new model nationally after the election in 2015. I hope to engage both committees at both houses in the coming months on the model and our plans for it. In the interim, some improvements need to be made administratively. For example, we'd like to simplify forms and procedures. We would like to improve the delivery of our training systems and programs, notably by investing in computer-based training. Furthermore, we plan to extend in all electors the use of voter identification cards as a proof of address when presented with another authorized piece of identification. This should reduce the need for vouching. Nonetheless, all these administrative improvements will have very little impact unless they are accompanied by a few specific legislative amendments. And for the most part, these amendments were identified in my 2010 recommendations, a report to Parliament, which were largely endorsed by this committee. They were highlighted again in my response to Mr. Neufeld's recommendations. 3 are specifically most critical. First, I would seeking a legislative change to allow full online voter registration, which would reduce the number of Election Day registrants and largely improve the quality of the voters list. The Act should also provide more flexibility for electors to establish their identity and residence electronically. This would permit us to offer and promote a complete online registration services in most provinces and territories. Secondly, I'm seeking changes allowing us to recruit and train electoral officers earlier. The provision granting candidates the authority to nominate electoral officers should be removed. I realize that this goes beyond my 2010 recommendations while dealing with the timing and responsibility of such nominations, but I believe it is warranted based on Mr. Neufeld's recommendation. Thirdly, the legislation should permit returning officers to appoint additional electoral officers, including supervisors, with the Chief Electoral Officer's authorization. Enough staff must be made available to ensure prompt and efficient service at the polls and check that the procedures are being followed. I would welcome the inclusion of these amendments, as well as those recommended in my report on deceptive communications with electors, in the government's anticipated election reform bill, and I'd be pleased to provide any technical support to the government in drafting the bill, as well, of course, to your committee during the review.
For my office in 2013 and 14. Elections Canada is funded by and operates under two separate budget authorities. The first is a statutory authority that draws directly from the Consolidated Revenue Fund. This authority funds all Elections Canada expenditures other than salaries for indeterminate positions. Our projected statutory draw for 13-14 is $85.8 million. The second is an annual appropriation which covers only the salaries of indeterminate position. For these main estimates, our appropriation is $30.1 million. It is this component that the committee is considering for approval today. As I informed the committee last year, Elections Canada has reduced its operating budget by 8% in response to the Deficit Reduction Action Plan. To ensure that resources are focused on the highest priorities linked to our mandate, Elections Canada completed a zero-based budgeting review in 12-13. In addition, we began implementing workforce adjustment measure and informed employees in January that 32 indeterminate positions would be eliminated. The agency plans and priorities for 13-14 are twofold. First, we are continuing to support the electoral boundaries readjustment process. Once the Commission have completed their final report and the new representation is proclaimed, likely this September, we will have 7 months to implement the new boundaries. Second, we will continue to pursue a number of initiatives to bring registration and voting services closer to electors. These complement our efforts to improve compliance and maintain Canadian confidence in their electoral system and in its administration. For example, we are redesigning the voter registration IT system to access a national voter list. This is necessary in order to integrate online voter registration services and offer it during the election. The new system will be an essential component enabling us to manage voter lists in real time at polling stations after 2015. As well, in advance of the next election, we are planning to conduct pre-election drives to improve registration rates among youth and Aboriginal electors. We are also planning to expand voting services on campuses and extend them to some other locations where these electors gather, such as community centers and friendship centers. With appropriate legislative amendments to provide full online registration, these initiatives will add convenience for electors and reduce known barriers, especially when combined with the use of the voter information card as proof of address. They would also improve the quality of the voter list, decrease the number of election day registrants, and reduce the need for vouching. Finally, we are continuing to enhance our information tools for political entities. This includes updating the handbooks for registered political parties and electoral district associations. As I conclude, it is my hope that any amendments to the legislation will be adopted by spring 2014. In order for my office to implement changes and secure additional resources in time for October 2015. We understand that the government intends to table a comprehensive bill, which will need to be considered carefully. I have provided 2 reference documents to the committee this morning, one entitled The CEO report on preventing deceptive communication with electors, and the other one, a review of compliance with election day registration and voting process rules. I hope these documents may be of assistance during our discussion. As always, I would remain available to this committee during its study of proposed legislation. Mr. Chair, my colleagues and I are happy to answer any questions the committee may have. Thank you.
Thank you. I believe we probably have some. We'll start first with Mr. Lukiski. 7 minutes, please.
Thank you very much, and thank you, Mr. Menon, you and your officials for being here. A number of questions, and we've got a couple of hours, so hopefully we'll be able to get all of them in the timeline. I want to start, if I can, just on a little update, if possible, if you can provide us with the ongoing robocall investigation. Now, I understand that since the investigation is still ongoing, there's probably very little you can tell us in terms of, you know, the details that you've uncovered so far. But I can assure you that our party, probably more than any other, would like to see a speedy resolve to this because, as you know, many in the opposition have been accusing our party as being the ones who perpetrated the voter suppression phone calls, the infamous Pierre Poutine investigation. We did not. We've stated that categorically. I will do so again. We believe in getting out the vote, not voter suppression. But, of course, until such time the investigation is completed, it is very difficult for us to prove that we had nothing to do with that. Justice delayed, justice denied. So even though I know that you won't be able to provide much in terms of actual information as what you have uncovered, I do have a few questions that hopefully will assist us in knowing what to expect once the investigation has been completed. The first one is after the investigation has been completed and either a report or a recommendation based on the investigation has been submitted, who actually makes the decision whether or not charges will be laid? Would that be your office or would that be the Commissioner of Elections office?
Neither of them. It will be the Director of Public Prosecution. The file will be sent to the DPP, who will assess whether there's a reasonable chance of conviction and whether it's in the public interest to file charges. If so, it will authorize the Commissioner of Canada Election to proceed with filing charge before the court.
Okay. Is there probably an unfair question, but is there a rough timeline, an average timeline? How long does that take after a report has been submitted, that a decision is made, and the final word, whether or not charges are going to be laid or not? What would be an average timeline after the report of the investigators has been completed?
I think that answer would be better provided by the DPP. Again, matters vary. Delay will vary depending on the complexity, the nature of the case. Again, they have to assess all the evidence and satisfy that it meets the criminal threshold in terms of evidence.
Do you have any, does either Elections Canada or the Director of Public Prosecutions have any procedures or practices or policies that you follow in terms of at least saying we will try and determine whether charges should be laid at an earliest opportunity? Again, I'm just trying to get to the point of if a report has been received, but then there's a long undue delay, then those people who are under question obviously are still waiting for an answer, and I think most Canadians would like an answer as well. So what kind of a procedure does your office and the Public Prosecution's Office follow, if any?
My understanding is as soon as the Commissioner is satisfied that he's gathered enough evidence to justify, in his mind, a prosecution, he will provide a brief to the DPP. As for the internal process, I would suggest that the DPP would be in a better position to answer your questions.
Mm-hmm. Is there then, final question on this, and then I'll move on if there's time remaining. Is there anything that you can provide, any information you can provide to this committee as to the status of the investigation?
Well, I think we all know about
other than it's ongoing. Yeah.
As for the others, these investigations are still continuing as we speak.
Okay. How much time do I have left, Chair?
2.5 minutes.
Maybe I can turn now to a completely different subject, and that's the New Brunswick model. You mentioned in your report you have plans to try and introduce different procedures that might facilitate better operations of voting at polling stations. My understanding, correct me if I'm wrong, is that you're suggesting, based on, I believe, what's happened in New Brunswick already provincially, that perhaps a system where when voters are entering a polling station, they are first met by one individual who gathers identification materials and then directs them to polling locations to try and better facilitate a quicker vote by members. In other words, rather than having people traditionally vote up at during rush hours at a polling station that maybe have 20 or 30 people in line, this one individual who gets all the information, confirms that they're eligible to vote, then directs them to any one of a number of different polling stations. Is that?
Whoever is available to serve the electors.
Now, has that been the practice in New Brunswick to date?
It is the model in New Brunswick. It's been modeled during municipal elections in New Brunswick for a few occasions, tested there, and it's been used in the last New Brunswick provincial election.
You're satisfied, based on what you've seen on the information provided to you or firsthand, that that is something that would be a worthwhile initiative for Elections Canada to pursue?
Certainly, it would need to be adapted to the federal context, but it's a promising model in terms of better service for electors, better compliance at the poll, and more efficient use of resources.
Now, did you want to try and do a pilot project based on that, or is that a firm recommendation that you were making to the committee?
No, I think it would be more prudent to test it in a federal election, either a by-election or even during the GE in a few ridings during the 2015 general election. I think we want to introduce technology also at the polls, and this needs to be fully tested before we ramp it through across the country.
Would you be prepared if, for an example, there's a by-election or a series of by-elections prior to the next federal election, would your office be prepared to implement a pilot project?
Subject to approval from the committees of both the House and the Senate, timely approval for the pilot, we could be ready to run a pilot for any by-election happening in the early 2015, if there are any call.
Thank you, Mr. Lukiski.
Yeah.
Thank you. We'll go to Mr. Scott for 7 minutes.
Thank you, Mr. Chair, and thank you, Mr. Miron, for being with us. No doubt you're aware of the decision that was released last week by Justice Mosley in the McEwing case, and some of the conclusions that were drawn of the fact that with respect to voter suppression calls, they had been orchestrated and they were widespread. The judge found fraud to have existed. The judge also signaled the high probability that the Conservative Party's SIMS database was the source of the information used for the voter suppression. He also observed that the Conservative Party, quote, made little effort to assist with the investigation at the outset despite early requests, unquote, and he's referring here to Elections Canada investigations. And one last thing is he did, this is to be very fair to all individuals, neither the CPC nor any MPs or individuals were found to have been specific perpetrators, but the judge did say, quote, the evidence points to elaborate efforts to conceal the identity of those accessing the database, and I emphasize the word those, and arranging for calls to be made, unquote. So basically the question, Mr. Miron, is were these conclusions by the judge in any way a surprise to you? And whether they were or they weren't, is there any way you can help us understand the challenges and the obstacles that Elections Canada has been facing in its own efforts to identify the perpetrators of the fraud?
I can't speak for the Commissioner on these matters, and I think we'll let everyone draw their own conclusion from the judgment of Justice Mosley, which speak for itself. I think in the reports you have before you today, there's a number of recommendations that deals with the challenge that we're faced during the investigation of what the affair that's referred to as robocalls. First of all, the lack of timely information being accessible to the Commissioner or to Elections Canada. The fact that there's no real standard in the industry for the retention of documentation, which is problematic. And the fact that the Commissioner has no authority to compel various individuals or parties to testify or provide information. These are three key issues that have been faced by the Commissioner, especially in this case. And again, he's facing the situation when people don't want to talk to him. He's got very little options, even though those people may not be suspect, but may have relevant information to the investigation. So again, I would focus on these three elements.
Well, in following you along those lines, obviously you're suggesting as well that we need legislative reform for these items to actually be in place. Now, we know that in March 2012 there was a motion adopted in the House by all parties requiring the government to table legislation by September, which didn't happen. We're 8 months later and we still don't see the reform legislation that we're all anticipating. The NDP did deposit our own bill in October as an effort to actually put forward some of the principles you just mentioned. But I have three sub-questions relating to this. One is, would the investigation likely be more effective or be different if what you're recommending now were in place? Secondly, if we are able to get this legislation before us, we haven't seen it, and it eventually gets passed, will that still help with the 2011 events? Because these are procedural investigative powers. Presumably they can apply to events that occurred before. I want to make sure I understand that that's correct. And the last thing is, how soon do we need to have this legislation?
I'll start with the last part of your question. In my opening remarks, I suggested that we need legislation in place with royal assent by spring 2014. The broader the scope of the reform, the more time we need to get ready to implement it. So I think we need a bit of leeway before the next GE in terms of significant legislative reform. Would the recommendation I put forward make a difference? Definitely. It would, I think, accelerate the process, and I think we're all concerned by the delays in those investigations, and the fact that, of course, justice delayed is justice denied, as one of your colleagues mentioned. These amendments are designed to improve the timeliness of investigation. It would also improve the ability to gather evidence, which is key for the Commissioner and for the DPP.
Including evidence relating to 2011.
On that one, I would probably I would have to see the text of the legislation. There may be transitory provisions in the bill. Without those, it would likely be applicable. The problem we have is that we would be 3 years after the possible circumstances that led to the investigation, and evidence may have long be gone.
Okay. And lastly, because I only have a minute, with respect to the comment by the judge about the lack of cooperation at the outset, despite early requests. Now, it was reported in the media, and I'm wondering if this is public knowledge or whether you can confirm it, that it took something like 3 months before the Conservative Party, through their lawyer, actually responded to an investigator's request for access to interview certain people. Were those media reports accurate in your knowledge?
I think those media reports are based on ITO procedures that were filed in court, where it was pointed out that there were some delays in dealing with the matters. again, the proposed amendment here that I put forward would alleviate those issues.
Thank you, Mr. Scott. Mr. Dion, 7 minutes, please.
Merci, Monsieur le Président. Bonjour à vous, Monsieur Méran. Et merci.
Thank you, Mr. Chairman, and good morning, Mr. Méran, and your colleagues as well. Thank you for being here. As to last week's court decision, I think we learned and confirmed some things that we suspected rather highly, that it occurred throughout the country, it was orchestrated, and it was aimed at those who were not intending to vote for the Conservative Party. It was based on the Conservative database, and that the Conservatives have done everything possible to try to delay the process. And the next step would be your inquiry on 100 or so ridings, and Canadians have a right to know who those responsible behind these fraudulent calls were. Have you had the complete cooperation of the Conservative Party in all of this investigation? Well, I can't speak on behalf of the Commissioner of Elections or the investigators on this matter. I know that they have meetings and discussions with various stakeholders and interveners, that the investigation is following its normal course of development, that in the Guelph riding, it's public information, there are 3 persons of interest who apparently have information that would be pertinent that refused to meet with the investigators. I think that's publicly known. It's in the public domain. Yes, and it's at the basis of one of my questions, in fact. Is it possible to refer these 3 recalcitrant persons to the RCMP? No, under the current law, the way it stands, they're not suspects, they're persons of interest. They may be in possession of information which is relevant, and there's no way to constrain or compel these individuals. They're not guilty of any infraction or offense, either criminally or civil law. So the recommendations would allow, well, yes, with a judicial authorization, of course, a commissioner could compel an individual to either testify or provide information. Were you consulted on the upcoming legislation? No. I was advised that their bill is being prepared and that it should have been tabled a few weeks ago, but I wasn't consulted as to the specific provisions of the law. Well, that's rather unfortunate. It's rather unfortunate. If you could provide advice in advance, it might avoid a bunch of problems. Well, I'm fully available to the government at all times to provide any advice or information. Mr. Minister, well, not Mr. Méran, rather. The few moments I have left, perhaps I'd like to ensure that we could avoid some of these escape loopholes in the recommendations you're making. You're recommending rather severe sanctions, up to $200,000, and significant jail time to fraudsters who try to pretend, who assume the identity of Elections Canada officials. Some individuals have pretended to be representatives of the Liberal Party in Mount Royal, for example. They call people on the Sabbath. We know that the riding has a large Jewish presence, and it's not Mr. Cutler's people that made that mistake, I'm sure. Are you going to cover impersonation of a party person, if you will? I believe that what I've recommended would cover that. It's false representation in the perpetration of an activity concerning Elections Canada. Whether it's Elections Canada officials or a political party, it's impersonation. And I think it's very clear in my report. Thank you. Okay, I could have read it another way.
Records of all communications made in Canada during the election. Why only during the election? Because it may disappear also outside the election, and now we are in permanent elections in Canada since some years.
We're trying to achieve a balance. I think the rules that are provided would cover all telecommunication. In terms of retention of documents, again, we are concerned that we not be subject to the will of this committee and Parliament, that we limit the intrusiveness in the operation of telemarketing companies. Again, there are different standards nowadays that apply. There's no uniform industry standard, and I don't believe there are formal regulation that governs the retention of the type of records we're looking for. So we've curtailed the recommendation to the specific issues that we were facing.
Okay. I have a concern about that, though.
I understand.
If we may look at that more carefully when we'll see the bill, would be something that we should revisit. Another point close to this one. Your next recommendation on page 39 of your report states that companies should preserve specified records if required by Election Canada. If required by Elections Canada. However, on page 27 of the report, you state that some companies don't keep record unless billing is required first, and do it for a short period of 3 days. So in 3 days, it's very short to have a complaint to Elections Canada and to be sure that the data is not destroyed before. So why not having an overarching rule stating that telemarketing services should keep records no matter if we are in or out a red period?
That's something, again, that the Committee and Parliament can consider. Again, there are, I think that it would probably require some consultation with the industry as to why they proceed the way they do. In terms of the practice right now, it's a well-established, it's a well-established standard in the industry that telecommunication, not telemarketing companies, telecommunication companies do not keep record unless they charge for communication. So you end up in the interesting situation where you use land phones where there's no charges. There's not necessarily a record of the communication coming to your home, but if you receive a call from a wireless, there's probably a record of that call. Of that transaction.
Nope.
Yep.
So I have other questions at next time.
Sure. Mr. McKenzie.
Chair, and thank you, Mr. Maynard, and your folks for being here today. I have actually more than one area I would like to discuss with you, but one of the things that I understand is nominating of officials to work at elections. Certainly, I know in my riding, and I suspect in others, that many of the returning officers have a very difficult time in finding the people to recruit and to staff. And I know a number of times that they have indicated that the responsibility was the candidates from all parties to produce lists of appropriate people to staff there. And in your recommendation, you're indicating you'd like to take that nominating process away. How would you fix the problem of not enough poll staff?
Maybe a few points. The Act requires the returning officer to go to the candidates who rank first and second in the last GE to recommend personnel. And the returning officer has to wait till day 17 before Election Day to get those names from candidates. The reality is that over a few election cycles now, the number of referrals by candidates have been declining significantly. In fact, nationally, barely a third of the electoral workers are identified by candidates. In fact, some part of the country, there's none at all. So that significantly impedes returning officer from starting recruitment much earlier and then provide the proper training in a timely manner. The situation we face right now is that the recruitment is done at the last minute, 2 weeks before Election Day, and suddenly a returning officer who has to recruit about 800 workers need to train them during that period. And again, during that period, I'm saying 17 days, but there's only 7 days before advanced polls. So within a week, they have to identify all the workers they need for advanced poll, train them, ensure that they are qualified, and then assign them to polling stations in the various districts. It's a daunting task for them, and it's an issue or situation that contributes to poor compliance with basic procedures at the poll. And I think Mr. Neufeld recommended to change that, and I'm coming back to this committee saying today it's time that we get rid of that rule. That being said, candidates and parties can always direct people to we're moving to a website recruitment tool. You can always move them to the website recruitment tool, and they will their referrals would certainly be considered by returning officer.
I'm not saying it's a bad idea because my group is one that refuses to hand over the names because it takes away from our workers and our supporters. I just wonder if you have a system or a plan where you're going to staff the polls where we've had that difficulty.
We do. It started earlier. For the last election, we introduced an online recruitment tool. We got over 40,000 applications online, and that will continue to grow as we promote it with Canadians.
Thank you. I come from a law enforcement background, and I have a great deal of difficulty in the suggestion that an accused has to cooperate with somebody that's conducting an investigation. It's never been my experience in policing. No one has to cooperate. I'm wondering if you can point to any other legislation where someone accused of something, doesn't mean they're guilty of anything, but someone accused of something has to provide the evidence that you feel would go towards proving or disproving your case.
I've not been talking about accused individuals. Every Canadian has rights guaranteed by the Charter of Rights that says that no one has to provide evidence against him or herself. What I'm looking for is the authority which exists for the vast majority of provincial electoral bodies, as well as for the Competition Bureau and many other regulatory agencies, the power to require a person to attend an interview. If that person, in the view of the investigator, may have in its possession information that are relevant to an investigation, that power would be exercised only with authorization of the courts. Again, it's not a free ride for the investigator, quite the opposite. And again, if in the course of an interview, an individual provide evidence that may be against their interests, the interview has to stop. They have to be told right away. And in any case, the information cannot be used against them.
Thank you. We'll go to Mr. Cullen. Try and keep it to 5 minutes. We were a little generous there.
Thank you, Chair. I'm sure the generosity will extend. A free and fair vote lies at the heart of our democracy, and hence us spending some time here today, and thank you for your work on that. There are obvious problems and loopholes that need to be fixed, that fraud has been committed, as was commented by my friend and by Judge Mosley, coordinated, systemic, widespread. I would suggest that the Conservative Party didn't do itself any favors in that case, and that the judge also noted, as you've said in his own recommendations, that they some sort of trench warfare in trying to deny the justice. I'm curious that now my Conservative colleagues are concerned about the principle of justice delayed is justice denied. My question is specifically this. You issued a report in 2010, more than 1,000 days ago, with some recommendations that would help fix the holes in our electoral system. Is that true?
There were certainly a good number of recommendations that would have helped us over the last few years.
You recently issued another report some 5 weeks ago with more recommendations. Has the government consulted with you on incorporating some of those recommendations into legislation?
No, not at this time.
Sorry, you haven't been consulted?
Not at this time.
The government announced that they were introducing a bill that was meant to fix some of these problems. Were you consulted on that piece of legislation?
No.
It seems to me that you would have something to say about this, having being the Chief Electoral Officer, having spent a lot of time on this and being an expert in this field. I'm surprised that the government felt that briefing the Conservative caucus was okay, but not briefing you on legislation to fix our electoral system was a good idea. I can't, you're an ally in this. This is the point of confusion that I have, and maybe you have similar sources of confusion, that one would assume that in restoring confidence, some people have said that we need to maintain the confidence of Canadians in our electoral system. I think after the robocall scandal and Pierre Poutine, there's actually an effort to restore confidence that when people vote in an election, when someone is elected, that they were duly elected, legally elected, and there wasn't fraud committed. I think Canadians are rightly concerned that the integrity of the system has been weakened. Would you agree with that statement?
I think the events of the last general election certainly cause of concern for Canadians, and they've told us loudly and in large numbers. That being said, again, we have in the current system different mechanisms to ensure that elections are run properly. There's access to the courts. So far, the courts have maintained the elections. But again, I do agree, and that's why I'm coming forward with those additional recommendations today. We really need to modernize our legislation. We're out of sync with the times. It's not been looked at carefully. We need to bring it from the 19th to the 21st century.
We have a 19th to the 21st century. It's a big jump. And we only get to bring that, though, if there's political will to do it. You can make all the recommendations you want. You don't have the powers right now to stop fraud in the 2015 election campaign unless you said you get legislation in time. You talked about spring of 2014 as sort of your drop-dead date.
Yes.
After that, any legislation that comes after that, will it be of use to Elections Canada in order to make sure that fraud isn't committed in the next election? Or you're up against the clock? It feels like time is running out.
Up against the clock. We have a fixed date, and yes, we need to know what are the rules of the game well ahead of the game being played.
So we know what the problem is, we collectively. We have solutions that are on offer, both from your office. Mr. Scott, introducing his legislation, took some of those recommendations, put them into a proposed bill. Yet we don't see the legislation. We asked the minister yesterday about it, and he went back to his in due course, or his, some sort of expression that means nothing. Not too distant future, excuse me, I get them confused. If the political will is absent, you can't do your job.
It's increasingly difficult to meet Canadians' expectation with regard to the fairness and the integrity of the electoral process if we don't modernize our legislation.
And by modernize, you just make it so that people can't commit fraud. That's what you mean.
No, I mean that we need to start looking at the way the voting process is designed. We need to introduce technology in the system. Right now, nowadays, I need signatures, document, papers, all these sorts of things that are not aligned with the times. People don't deal with, Canadians deal less and less with paper. They want to deal with us electronically.
The final question, is it lawful for a senator to campaign during the writ period and also claim expenses? Does that now involve your department? Does that involve your office?
Well, the Elections Act provides rules as to how you can contribute to participate in campaigns. Whether you're senator or MP, we have a handbook that describes pretty precisely what has to be reported in returns from candidates and for parties, and the cost incurred in campaigning in favor of candidate or a party need to be reported as election expenses.
Thank you.
Thank you. Mr. Chisu, you're up. 5 minutes, please.
Thank you very much, Mr. Chair. Thank you very much, Mr. Myran, for your great presentation and for the great recommendations that you have done and you are proposing. I would like to ask a question. By the way, by my profession, I'm a professional engineer, so I have a licensed professional engineer, so I'm not, like many of my colleagues, distinguished lawyers. So my preoccupation during the last election, it was to respect the law, because if I would not respect the law, I would lose my license. And the license is very important for me. So when you are looking at the database, I'm asking about the voters database. How you are keeping this database updated? Because there are a lot of changes, and I think this is a mobility of our people, you know, and it is very important to have a good database in the way that you are avoiding exactly the things that we are looking for, avoiding fraud, avoiding other let's see, unnecessarily negative events. So that is my first question. The second question is how you updated or how you are updating your administrative changes, because obviously we are evolving and the need of administrative changes are evolving with time. So when it is the last time that you updated the administrative changes which are on your purview and your powers? And secondly, when you updated the procedures, for example, requesting the time that if you have a violation of the elections, how you are proceeding forward to lay a charge or to do something which is correcting the situation.
With regard to the register of electors, again, we continuously keep it up to date. We get information from various sources. I'll just name the main one. We get information from CRA. When Canadians are filing their tax return, they can tick a box. That information come to us. If they change address during the year, that will be noted in our register. Similarly, we get information from Driver's License Bureau in most of the provinces and territories, which again will update us on various changes of address. We also get information from Citizen and Immigration Canada with regard to new citizens. We also get data from the Vital Statistics Bureau, which provide us the name of deceased electors. So this information is provided regularly and constantly used to update the register. That's between elections. And again, I would point out that in any given year, there's 18% of electors whose information change in the register. Now, in order to correct that 18% variation, make sure that the list is as up-to-date for election, we have various revision procedures that are prescribed by the legislation during the election. Electors can contact their returning officers to update their information or register. They can be visited in specific neighborhoods across the country as a result of targeted revision. And finally, they can register on polling day at the poll. So that's how the list is constantly being updated. We're proposing that with online registration, it will be easier for electors to register and update their information. They will not have to contact the returning officer. They will not have to wait for registration day, polling day. They will do that at the convenience of their own under secured measure. They will be able to update their information and ensure that they add the VIC with their right address and be directed at the right polling location. I'm not sure if you want to carry me. No, sorry.
About 15 seconds left in the 5 minutes. So.
I would suggest that we update our administrative procedure continuously. We're committed to constant improvement of our processes. We engage political parties, we engage Canadians, we engage parliamentarians on these matters. We've discussed with this committee Vision 2015, which discussed very specific initiatives designed to improve the administration for the next general election.
Thank you. Mr. Armstrong, 5 minutes, please.
Well, thank you, Mr. Chair, and I want to thank our guests for being here today. Someone who's been involved in politics on the political side as a campaign manager. I know there's been many criticisms, and I'm sure you've heard them on the electoral list and the accuracy of the electoral list and changes that constantly have to be made. And you've said here today that you're hoping to use technology to kind of correct some of these problems that exist with the current list. Can you speak a little more in depth on how you see technology actually helping make that list a little more accurate?
Well, first of all, what we're proposing, and we launch a limited service allowing electors to verify online if they are registered and if they are registered at the correct address. They can also change that address if they want. Because of the way the Act is drafted currently, these services are quite limited during an election campaign. You cannot register or you cannot move from one riding to the next during an election, and that's the purpose of the recommendations I've put forward to the committee. Having the real-time update on election and offering the opportunity to electors to update their information will improve the quality of the list. At the same time, as we move forward, having the list available electronically at the poll will make sure that the person is not registering or trying to register more than one place for an election day. Even, albeit it's rare, if it happens, it would be detected through the system. In addition to that, the system would automatically tell candidates' campaign who's voted during the day. Right now, we produce small reports every 20 minutes, and it's cumbersome to fill, not that useful for candidates, I understand. I think by having a live update as to who has voted would be much more efficient for campaigns.
And you say you're going to have the ability to pilot project this or by-election or maybe after 2015. Is that what the timeline we're looking at?
For 2015, we would like to introduce it as a pilot in a few ridings. I don't want to wait in 2015. I'm asking for full online registration services. Live lists at the poll, that would be at the pilot, to be expanded across the country in 2019.
There are going to be some that are concerned with the security around this process. So we used to do door-to-door, enumeration, where someone would actually come to the door and we get ID, and a lot of people that have worked in politics for many years on the party side, thought that was a much better system. But with an online registration system, I think there probably is some merit to it. But what steps can you take to ensure security around that system?
We have devised an authentication system based on what exists currently that's available to us. Until we get a national authentication system at the federal level, we'll have to patch through a system of varied authentication. To verify if you are on the list, you only have to enter your name, your riding, or your address. That will confirm if you're on the list. If you want to change your address, as we discussed with this committee a few years back, you will have to provide a secret to Elections Canada, which is your date of birth. If you want to do, during an election, to add a new registrant or add change from a riding to another, we will ask you about your driver's license, which is information we already have. And that will allow us to authenticate who the user is.
I'm going to switch just for a second to the new voting model that you've talked about piloting as well. Mm-hmm. When a voter walks into the poll, what is different? What will they see different in the new voting model as opposed to what we've done the last several elections?
I think the best illustration, maybe a comparative I can use, is imagine going to a bank. Normally there's a reception desk at the bank that tells you what service are you looking for, sir or madam, today. If it's standard services, you're directed to the first teller that's available. If you need a special service, you're directed to a special office, special advisors. In a nutshell, that's what we are looking to build. That's what the New Brunswick model is about. It's a system that's centered on elector as opposed to polling station. A physical table, we're focusing on serving electors. Benefit of it is that it will reduce waiting time, especially at advance polls, where the lineup can build very quickly. Process is more cumbersome there, so it's not rare to see people waiting for an hour, for example, in advanced poll. This system will accelerate the processes, will isolate those who need special or exceptional services. They will have a special track there, and they will need with specialized officers, having received specialized training to deal with exception. So that, I think, would be a better service elector, more efficient use of resources, and probably fewer resources being used in this model.
Thank you. Madame Latendresse, you're up. 5 minutes, please.
Merci, Monsieur le Président. Merci beaucoup, Monsieur Méran et tous vos collègues.
Thank you very much, Mr. Méran, and all your colleagues who are accompanying you this morning. We're very pleased to have the opportunity to ask you a few questions and to explore these in a little bit more depth. It's quite important. In your report and in the recommendations, you mentioned a few pilot projects that you'd like to implement to encourage and promote more youth participation, for example. Maybe more presence on the campus, polling stations and all that, and to allow youth to perhaps work as election officers to a greater proportion, as was the last election. The committee is quite aware that commitment and engagement of youth is something that's very, very important to us all, to the NDP in particular. We'd like to cooperate with Elections Canada, of course, on any of these initiatives. So today I'd like to announce to the Commission that I'd like to put the motion forward. My motion would be that this committee recognize that reports of the Chief Electoral Officer submitted to Parliament from 2010 onward demonstrate that if Parliament does not modernize our electoral system in order to engage young Canadians, lower and lower percentages of eligible voters will turn out to vote in future federal elections. And
2013 on potential mechanism to enhance youth electoral engagement in Canada, with the view to implement such change before the next federal election, including modernizing the online voter registration system, ensuring there are polling stations on university and college campuses across the country, recruiting and training more youth to act as election officers, raising awareness about how and where to vote, especially among mobile college and university students, considering an electronic voting system, considering automatic registration, and removing barriers to pre-registering young people at age 16 as prospective voters in advance of eligibility to vote at age 18. Je l'ai en français, en anglais pour...
And I have the text in English and in French for the clerk, if you'd like to see that. So, more specifically then, my question would be as follows. The various recommendations, various pilot projects that you're putting forward, do you think that cuts to Elections Canada budgets will affect those initiatives? Well, as I indicated in our annual business plan and our vision, Vision 2015, we'd like to reduce obstacles and barriers to everyone. Youth and Aboriginal populations in particular are a priority for Elections Canada. So we will allocate the resources in a priority fashion to those initiatives. Could you perhaps elaborate a little bit on the campus-based polling stations and what you intend to do to increase their participation? Well, there already exists polling stations on Indian reserves. What we're trying to do is do the same as what we do for various workers who work in mining camps or the oil sands in Alberta. We have special polling stations for these populations. So we'd like to implement or model that particular process on campus. We can't do it for all university campuses in Canada, of course. We'll have to deal with the major universities and see where we can selectively pick some community centers, friendship centers in Aboriginal cases, or campuses. Super. Now, online registration, could you extend your thought a little bit on that, please? How this might affect younger populations? One observation that we've made in terms of registration is that registration rates is about 72%, whereas the national is 92% youth compared to general pop. And for various reasons, there has to be the consent of the elector before he is registered, for example. I know that in British Columbia and some other provinces, we've adopted the inverse process. It's a negative optioning. You have to indicate that you don't want to be registered to vote. We have information from vehicle registration bureaus, ministries of transport for some various information. But we need the positive consent of the individual. So we write, 300,000 letters a year addressed to these youth. Unfortunately, the response rate is very low. I think they'd answer perhaps if we emailed them, but by post, they don't answer. And it's very difficult to know where to vote and when to vote if you're not registered. You have to look around for that information. So we're trying to register youth, particularly Aboriginal youth as well, and we want to see them engage in the process to a much greater degree.
Time is complete. Mr. Lukiski.
Thank you very much. How much time do we have?
5 minutes with you.
All right,
You've been very generous here so far, I guess.
I've got a couple of questions, but briefly, I want to go back to the personation issues and some of your remedies for that. I don't know if I'm understanding it correctly, but I use the term personation as opposed to impersonation, just to be accurate. You've talked about bringing in some sanctions against people who personate either elections officials or party officials or candidates. Is that correct? Would that extend, and I'm going back to the case that we saw in Guelph last year, where, to my knowledge, is the only documented illegal robocall case in the last election, where the Liberal candidate at that time sent out a robocall. Actually, it wasn't an automated call, but it was a live person on the. No, it was a recorded call. Not only did they not indicate that it was the Liberal candidate's campaign team phoning, the woman who recorded the call used a fraudulent name. In other words, didn't identify herself accurately. She used a different name, which to me indicates it was intended to be deceptive. But nonetheless, would that be captured under your recommendations? They're not trying to personate an election official. They're not personating, obviously, a different election official, but they are conducting what can only be considered to be an illegal robocall. Would that be captured under your recommendations, that situation?
The case was sanctioned by the CRTC under specific rules. As put forward, the recommendation would not cover such a situation, and again, we have to be careful. And first of all, I haven't heard the call itself, but again, I think in all sorts of promotional activities, there's all sorts of fictitious characters that are being used by all campaigns and all candidates. And I wouldn't want these as being characterization of personation. I think, so in a nutshell, the recommendation put forward would not cover the example that you mentioned.
Okay. Although I think it should, but that's fine. The other thing I want to get to is something that you had identified on the compliance side of your report. And basically, it deals with the issues that you've identified, the problems you've identified in polling stations across Canada in the last election. I think it even infers that, some of these problems were far more widespread than that and went back a few elections, where there were a lot of difficulties with procedural non-compliance at polls. And even though your report suggests that you don't think that it really impugned anybody's right to vote, you didn't stop anybody from voting who should have been allowed to vote, clearly there were some problems that could affect the integrity of the vote. My question is, number one, why did it take so long to do? I congratulate you on coming up with a report that identifying that you had some internal problems. Why did it take so long to identify those problems? And do you think it was mainly a function of the people who were manning the stations were really volunteers and poor training, or Can you give us some sense of why the problems occurred, and more importantly, what are you going to do to try and fix them in the future?
With respect to the timeliness, I should point out it's the first time Elections Canada does any sort of post-event audit of what occurred at the poll. I'm not aware that any other electoral management bodies, either here in Canada or around the world, do any such audit. In fact, there's an old saying among EMBs that you don't want to look under the hood. So, that being said, I thought that given the issues that were brought in the Etobicoke situation, we needed to understand what was the state of the land and how can we address them. That's what Mr. Neufeld did. It's a complex, there's many contributing factors, and the one thing is that the whole system was designed for Canadians in the neighborhood to serve their neighbor for a day and allowing them to vote. And that's great when you think of it. I don't think that we can blame those people which have extraneous working conditions, poor pay, long hours, very complex procedure, limited training because of the constraint that exists, and increasingly clients that may be difficult to serve at times. So I think our approach is to say, no, we need to address the many contributing factors. Short term, we've put forward some recommendations to address it for 2015. We know that it will not be enough, however. We need to do more. We need to redesign the whole voting process. We need to rely more on technology to ensure compliance than human behavior. It will always be human behavior, but we need to minimize that. I've got examples, for example, that occurred and came to light in Etobicoke. Mother showing with her son or daughter at a poll before neighbors that know them. The daughter doesn't have the piece of ID, so she needs to be vouched. The staff does the procedure, but instead of putting the name of the mother, puts the word mother on the form. That's an irregularity, but I don't think anybody would challenge the validity of the vote that took place there. In a nursing home, for example, for whatever reason, the electors, the residents, needed to be vouched for. Well, they were vouched by a staff member, I believe it was a nurse, who certainly knows the residents and who they are and that they reside there. But it's an irregularity because that nurse certainly did not reside in that home. So technically, she was not allowed to vouch. Therefore, the vouching was irregular. Doesn't mean that these residents would not, I think everyone around this table would agree that these people were legitimate electors and should have been allowed to vote. So we need to rely more, better training, specialization of tasks, but also technology to deal with those matters.
Thank you. Mr. McKenzie?
Chair. Mr. Marand, I think one of the focus has been a great deal on robocalls. I'd just like to have your opinion. Is it a fact that all parties keep lists in computers, data that makes it available for them to get out voters?
My understanding is that most national parties, larger parties, have some sort of database of electors and their supporters and members of the party, of course.
Sure, and that would be logical if your intention is to get out the vote. I just think that's the 20th century or 21st century now. That's the most logical thing. And is also equally true that candidates and parties use technology that gets referred to as robocalls, I think, in a general sense?
Correct.
Yeah.
Increasingly.
Okay. And so much of what has been made is always attributed to the Conservative Party, and yet perhaps the only conviction registered has not been the Conservative Party.
Yeah, but
that be
we're
fair?
Talking to two different things, but
but I think that's the reality. I mean, there are certain.
There were findings by the CRTC.
Yes.
I'm not sure they are convictions,
sure.
but there were findings by the CRTC.
And I think somehow that gets lost in the translation, and I'm not trying to to build it up on somebody else, because that's not fair. But I don't think what's happened in recent past, blaming everything on Conservative Party lists, is equally fair. But that's my opinion, and I would expect you would understand that.
My recommendations are focusing on looking at the future and how do we provide better
In a
rules for
general
everyone to know how to use those communication tools properly.
Sure, in a general sense, across the board. And I think that's fair. With respect to the legislative changes proposed in the recent compliance report, it would appear that many of those things were recommendations you made to this committee after the 40th general election, and I think most of which this committee endorsed when you brought it to the committee. I think that's a fair assessment from past.
Largely, yes, and I pointed out some variations today in my presentations. Yes.
Okay, and would it be safe that it's accurate that, in fact, they have been recommended to this committee by your office, I think, as the past one, and how helpful to your office would the implementation of many of these legislative changes proposed both in the recent compliance report and in your report on the 40th general election be towards significantly reducing the number of errors made by election officials at the polls?
They would contribute significantly for 2015 because, again, with flexibility in recruitment, more time for training, better training tools, etc., online services for registration, I think we can make a difference. Will we entirely fix the problem? I don't think until we have redesigned the whole process.
I think it's fair to say that constant improvement is always something that's out there. We'll perhaps never get perfect, but I think that you would agree that you've recommended, this committee has concurred in it, and so now it's the implementation of many of those things that have to occur.
Well, before implementation, we need to see legislation that
But I think this committee did concur, and I think in the past.
It did concur, certainly. I think it was in summer 2011, but we're still waiting for legislation there.
Okay. Yep.
Madam Chamel.
Thank you very much, Mr. Chairman. I'd like to follow up, Mr. Méran, with a few questions of my colleague as to the 18 years of age and the envelopes that you send to these young people, encouraging to register. Do you have any recommendations specifically to reach out to engage young people under the age of 18? Well, there's a number of recommendations that could be made, depending on a public debate on the issue, of course. As I mentioned earlier, we should be able to automatically register those who come of age to vote, rather than use the negative optioning process that we use now, where we have to get explicit consent. In some countries, it's mandatory to register to vote. I'm not saying we should go that far, but once we know who becomes admissible and eligible to vote, we should be able to, unless, of course, they would like to not register specifically. Another thing that we might be able to do is to use other data, if you will. Young people may get a driver's license at age 16, for example, and we're not allowed to maintain records on these youth under the age of 18. We have to wait until they're 18. But the information is accessible. Or perhaps we should start registering youth perhaps at age 16. You know, insofar as while they're still within the family home and before they take off for university or jobs, and have it in waiting and suspension and activate it when they turn 18. These are all formula that exist in various other countries of the world and being explored even here, like in British Columbia, for example. Thank you. I'll talk about staff and employees a little bit later, but I'd like to come back on something that appeared in the papers today. Electoral contributions that were made in certain ridings of a specific riding, 40 individuals in one day. Now, this was not the most recent election, but when you notice that a massive number of individuals will make a contribution, an electoral campaign contribution, all on the same day, all at once for one candidate, wouldn't that raise a flag for you? I mean, I'm not saying that it's illegal, because there's a right for 40 individuals all working for the same company to make a contribution to the same candidate, obviously. But does Elections Canada have any capacity to perhaps look at things preventively? Well, look, if we obtain additional information or information, the simple fact of contributing to a political party is a perfectly legal act, respecting any maxima, etc. That people may consort together to contribute to one candidate, that's not a conspiracy, that's not a criminal conspiracy, that's perfectly legal. However, if this concertation is associated with or linked to a reimbursement of some sort by someone within the campaign, well, that may be marginally tending to the criminal. But everyone is entitled, any group is entitled to make contributions, individually or collectively. Now, we note that sometimes you will get contributions that are all occurring on the same day. Well, that often happens, particularly if there's been a fundraising dinner the night before. We have no idea as to where these people work. This is not information that Elections Canada requires or has. But we're always listening, and if there's any information that somebody feels that should require further investigation, we'd be glad to do so.
The annotation in the estimates saying that you wouldn't be going ahead with an e-voting project, is that purely for privacy reasons, or is it also budgetary?
I would say it's both financial. We realize as we looked at it more and more closely it would be expensive. And in the current fiscal context, we thought it would not be advisable for us to invest massively in this initiative. We also have concern about, mentioned it briefly for online registration, we have concern about the proper authentication method and the lack of an existing universal one at the federal level. We are also, I think at some point of time, everybody thinks that online voting means you can vote from any computer at home, at work, or anywhere around the world. And I think that would require much public discussion as to whether we are, as a society, comfortable with having unsupervised voting to a large scale. Some would argue you already have it through mail voting, but again, it's a very small piece. Are we, as a society, are we at a point where we would accept unsupervised voting for the vast majority of electors? I think that this is a discussion we need to have. It's beyond my my jurisdiction, I would suggest. In terms of security, these matters can be dealt with in due course.
Thank you. We'll do one more round. We'll do we've done one full. We've captured everyone in our first round, but due to time constraints, I don't think it will fully get through a second. So we'll do a 7-minute round, one for each, and call it a day at that point. Mr. Armstrong, you're up first. Share your time or use it.
I'll share my time with Mr. Lukowski.
I thought you might.
Just really quickly, the compliance report, the usefulness of the ACPP. Now, this is the advisory committee of political parties. Do you find this is a useful group? Do they provide adequate information to you?
Mm-hmm. It is a useful group. Can it be made more useful? Probably, and we're looking at ways of achieving that. It's absolutely key for Elections Canada to have a direct connection with political parties, to understand their concern and to share with them our initiatives, because we want to make sure that we're responsive to their needs within the constraint of the legislation, but we're responsive to political parties' expectation. We want to facilitate their work, facilitate compliance, and the ACPP serves a useful purpose in that regard. The voting model, I think parties have a key interest in that, and we're going to use the ACPP to validate some of our approach with regard to redesigning the voting model. They've been quite involved in online registration at the time. They will continue to be. When we explore the alternative voting device for disabled electors, they were involved in that process too. So we'll continue to involve them. We also involve them in regulatory initiatives. So we have a full agenda with that.
Great, thank you. I'm going to turn the rest of my time over to my colleague.
Thank you very much. You know, we haven't, the entire time here, we haven't really talked about much about your budget and the main estimates. So a couple quick questions there. I know we haven't got much time. You mentioned, I believe, in the last appearance, or it was last year sometime, that you were going to a zero-based budgeting model. Could you give us an update on that process and what your findings have been, the effectiveness of that model?
Yeah. We've completed it late last fall, and the result of it is, as I mentioned in my presentation, the net result of it was we would have to eliminate 32 indeterminate positions at Elections Canada. I would suggest half of them as a result of fiscal restraint. The other half as a result of the need to reinvest in an area of higher priorities. So we've reinvested a bit of money in the Commissioner's office to support investigative work. We've reinvested in political financing because they were finding financial pressure. And we've also reinvested in the whole area, the new area of compliance at the poll, which need to be resourced if we want to progress on these things.
Did I hear you correctly? I'm sorry, I don't want you to repeat yourself. Did you say this exercise is going to result in 32 reductions of staff positions?
Yes.
Full-time?
Yes.
Out of what is the staff complement currently?
372.
Has that increased, decreased, stayed about level over the past, say, 2 or 3 elections, or have you seen a need to have more people in your staff complement?
There is a need to have more people. Before we did this zero-based budgeting exercise, we also did an A-based review 2.5 years before the fiscal restraint settled in. And at that time, we found that we were missing about 25 indeterminate positions. But again, things changed. We had to deal with the fiscal restraint, and we've moved from that. But at some point of time, I will have to go back to Treasury Board. We will have 30 new ridings in 2015. Need staff to support those ridings. So there's a number of things out there that are new and will, I believe, justify additional resources.
Okay, let me see if I get this clear. My understanding is that the budget that affects general elections is not affected because that, statutory requirements take care of that. So if there's going to be 30 new ridings, the majority of the cost would be come election time, would it not? But are you suggesting that just because there's 30 new ridings, your office will require new staff?
Yes,
and how does that work? I'm not quite connecting the dots here.
There is, we make a distinction between 3 phases. Ongoing operation to sustain the organization. That's the core minimal staff we need to continue to operate and make sure that you have a list every year, that maps are up to date, and all these things. In addition to that, in the year before the election, we get into readiness, where we now bring ROs into the fold and start preparing them for the election, and then we have the conduct of the election. What's readiness and what's conduct? That's statutory authority. Whatever is ongoing is indeterminate staffing. And this is the core group of workers that are needed to make sure that in 2015 we'll be able to run the election.
All right. we're just 2 1/3 years out from the next federal election. I know that it's difficult to estimate the cost of general elections and by-elections that far out, but would you hazard a guess? It's going to be a larger election, obviously, with 30 new ridings. And based on that, based on what your staff complement may be, even a percentage, what do you think the percentage increase might be compared to the last election? Is there any way you might be able to hazard a guess there?
I think it would be highly imprudent for me to project for
when do you think then? When do you think you would have an estimate?
Probably at the end of 2014, we will have a good sense. We'll know about the legislation. We'll know about the initiative that we discussed today. In terms of Vision 15, we will have been able to cost them out, and we will, as we always do, establish a budget for the election. I would point out to the committee that over the last 4G, our costs have remained stable. It costs about between $11 and $12 per elector to conduct an election. And that has remained at $11 to $12 despite inflation, various changes. We've managed to find other efficiencies. So we will continue to do our best to contain costs.
Thank you. You're all doing very well today at asking that long question with just a very little time left. And so it's been reflected in all of your time today. Mr. Cullen, let's try and finish up. We'll go to Mr. Dion after you.
We've talked a lot about restoring integrity to the electoral process and the concerns that Canadians have, seeing all of these instances. I also asked you about what consultation or total lack of consultation the government has made in terms of addressing this fundamental issue, how to restore that integrity. I'm also reflecting on Judge Mosley's decision, the one that you've also closely watched and listened to. And there was a quote from his ruling that said that Conservatives showed little effort to assist Elections Canada with the investigation. Do you recall that quote from the judgment?
I'm not sure if he was referring to Election Canada. I would have to know.
Possibility it was reported incorrectly. That engaged in trench warfare. Here's my question about pattern. That if the judge found that, whether it was your investigation or it was an investigation of the court itself, that there was great reluctance and feet dragging and all the rest of those things to get at that justice and the denial of that justice from the delay, we also then transferred over to the legislative change, the rules changes that we need, the political will that has to come from Parliament, and a similar dragging the feet delay. We now have a deadline that you didn't use that term deadline, but you said if you don't have legislation in your hands and confirmed by the spring of 2014, is that correct? That we will conduct the next federal election under the same rules as we did the last one, in which all these fraudulent calls went on, and that some Canadian voters were disenfranchised from the opportunity to vote.
Or under is that the rules will be poorly understood and we will not be sufficiently prepared. And when I mean we, I mean not only Elections Canada, I think candidates and campaigns need to know the rule early on.
Right.
So, as well as Canadians. And I think it's important there's been ample of early notice about what...
So you talked about not wanting to look backwards, but of course we look back to try to fix going forward. And the cloud that has now surrounded some of those elections and people currently sitting in the House, unless we're not to have that cloud over the next election and the integrity questioned again, we need the changes. Yet we see in due course, we see these answers from the government and no consultation with you, who are the experts on fixing the holes in the system. This is what is confounding to many of us, that it would be the first call, if I saw you as an ally as opposed to an enemy, that I would make, is to confer and consult in meaningful ways, not what we've seen so far. I asked a passing question at the end of my last round about the Senate, just in terms of I want to know what triggers an investigation on your part, similar to the House of Commons, but also applies to the Senate. Is it a reporting of a complaint that a member of Parliament was claiming expenses, or a senator was claiming expenses while campaigning, that you begin an investigation? What can initiate an investigation on your part, and does it fall within your mandate?
Investigations fall under the mandate of the Commissioner. If I get a complaint, for example, depending on the issue that may arise, but let's say it's a complain about claims made during a campaign. Normally, the first thing would be to see if there's enough facts in the complaint to validate the information. Second thing would be to look at the audit of the return we did to see if those claims or expenses have been reported and how they've been reported. And if there are reasons that there's an issue there, it may be referred to the commissioner.
Right. So I just want to follow this through. It initiates with a complaint. I saw Senator so-and-so during the writ period campaigning.
Yeah.
You can then look at the campaign's statements to see was there any filing of the costs of having that senator there. If they're not accounted for, if the campaign didn't pay for their travel, is that the kinds of things we're talking about? The per diems, what kinds of things are you looking for? I'm just trying to understand what powers you have and what kinds of things you're looking for if a complaint is made.
Again, and that varies depending on the political entity. For candidates, we have access to, we're entitled to ask for all the receipts and all the charges.
Of course.
Documented. So again, if there is an indication that so-and-so was campaigning in there, we can ask questions, we can ask evidence, and validation of the costs that were reimbursed. And that, by the way, would trigger a reimbursement from the
That's for a candidate. That's for the candidate themselves.
For parties and EDAs, we don't have, I mentioned that in 2010, that we don't have access to supporting documents for various claims.
And you can't insist on getting those?
No. So again, that's one another tools that I've been looking for.
You've asked for this tool?
Yeah, in 2010.
Since 2010?
Yeah.
So you've asked for the tool to catch somebody who is campaigning illegally or charging illegal expenses, essentially, to the taxpayer in this case, to campaign for a candidate. You right now don't have access to the documents to verify whether they were charging back?
I've got access for documents related to individual candidates' campaign. I don't have it for whatever has been charged to a party. So I don't know what's been charged for to a political party or even an EDA in that respect. So some of the campaign activities may have been charged to the ADA or the party.
But you don't know?
Well, they will report expenditures at large. I don't have a way of verifying specific expenditures. I don't have access to receipts or invoices.
But you want access?
I've asked for it in 2010.
2010?
Yeah.
I want to thank you. It's difficult to not comment on that. That if those in charge of the election are asking for certain tools to make sure that the elections are fought fairly, and not given those tools, one can only draw a couple of conclusions. Either it's out of laziness or by intention. Those are the incompetence, I suppose, is a third option, but that's too often levied at the government. I want to talk about youth participation for a moment. That's perfect. Do you believe that if people were able to vote online as they do for the leadership of parties, for example, a system that is currently employed, that it could potentially open up the door for youth participation to a higher level in particular, as they are much more a generation that exists online?
Thank you. We'll see if we can get the answer under Mr. Dionne's questioning. Your 7 minutes is complete. Mr. Dionne?
That's unfair. You put me in the obligation to not have an answer about
you don't have to ask that question.
But I want my minutes.
If we can.
No, thank you. Thank you very much, Mr. Chair. I will unfortunately, Mr. Cullen, I will focus on my questions. But I just want to give you last opportunity, Mr. Meran, to maybe to add something on the two main concerns that Canadians will have, I think, after this meeting we had with you. I mentioned that in French at the beginning of our meeting. The first concern is that you have not been consulted by Minister Upal about the next legislation. And the second concern is the possibility that the Conservative Party will continue to derail the proceedings for your own investigation, as they did according to Justice Mosley up to now. So I'll give you an opportunity about these two concerns. Is there a way that you will be consulted in the coming days about what is happening now with the new legislation?
I'm always available. would suggest, however, that fortunately we have the mechanism that provides in the legislation that allows me to bring those reports to the attention, and I'm sure I will. I'm assuming that the government will consider, and I think there were statements to that effect, that they will consider the recommendations that are brought forward in my reports. I'll have to see with everyone else what's in the legislation. And
it's very interesting reports, but as you have seen, we have a lot of questions on the report, and I would like the Minister to take the opportunity to do the same. And about the current investigation and the need to have the full cooperation of everyone, I ask my Conservative colleagues to speak to their government and to be sure that and their party, and to be sure that they will stop to do what they have done according to justice mostly. Is there anything you may say about that?
I think the investigations are being carried by the Commissioner. I think he's facing challenges on various fronts from time to time, and I have confidence that he will be able to overcome them, especially if we get through the recommendations that we've put forward today.
Okay, speaking about these recommendations, on page 33 of the English version, you state that personal information collected by political parties misused by local campaigns remain the responsibility of the parties. My question is, have you used the word campaigns purposely, or is it something that will apply also outside campaigns?
To me, we're focusing in the context of those deceptive communication. But at large, I think, my view, my recommendation is that parties, like any other organization, should be subject to the universal privacy rules that apply.
Always.
Always.
Not only during campaigns.
And to me, it's an issue of trust between Canadians and political entities.
J'ai une grande inquiétude que si on se concentre seulement sur les campagnes.
I have a major concern that if we only look at campaigns, we'll miss the pre-campaign preparations. And my other concern is on third parties. If some party wishes to do something that is not quite ethical or above board, let's say, and have it done by a third party, arm's length type third party, what can we do to prevent that type of activity? Well, first of all, I think if we are clear as to the rules and regulations on the privacy of information, as you know, the law already says that the information may be used only for the purposes for which it was gathered and collected. And if we are to respect that rigorously, make sure that it is used only for its appropriate purpose and only for the purposes for which it was collected. One of the problems that may arise, of course, is that Elections Canada does transmit electors' lists or voters' lists, name and address only, to all political parties. Now, the law is very clear on that as well, what may be done or not be done with this information. Well, one of the situations that we see more and more now is that the voters list is being simply integrated with the individual party's database. Once the information has been integrated into party's database, information database, they've lost the intrinsic quality of being a voters list. It's no longer a voters list. It's all becomes data within a database. So, as a minimum, I believe that we must enhance and tighten up the regulations on the use of this information that's obtained in a privileged fashion. Should the political parties contact you looking for who this information might be disseminated to? Well, the parties, in order to obtain voters lists in future, should obtain an attestation from an independent third party that the rules of protection of privacy will be respected and can be respected. And the information is not to be shared other than for the purposes indicated initially. Either you're fundraising or you want to share information with electors. Now, this information is very limited in what. So we have to be careful with whom we share that information. Yes, well, but parties should know that. There's no reason to inform Elections Canada. We feel that there should be an attestation from an independent third party that the information is to be used only for the purposes for which it had been collected. Time for one last couple of seconds? Very quickly then. Automatic count. You suggest a New Brunswick model here be used. Have you taken a look at spoiled ballots or rejected ballots? I'm told that in New Brunswick, if you voted for the mayor, for example, but none of the councillors, the whole ballot is rejected. There can be problems, particularly at the municipal level, because it's a more complicated, multi-level vote. Federally speaking, I don't think there should be that much problems because we're only taking one box, one candidate.
Of our witnesses today, I'd like to thank you for coming. It's always been special having you come visit us, and I'm sure we will have you again soon. We'd love to be able to deliver redistribution to you on time and complete, and it's been a nice break today not to be doing that. This committee will return to that on Thursday, and we endeavor to get you all of the information on new ridings on time for your next election. I would like to suggest we go in camera to discuss 2 or 3 issues, and if we could do that fairly quickly, we'll finish on time. We will suspend for a couple of minutes.